a high-level closing panel is the brief here. So all of our panelists, you're invited to really reach for the clouds in terms of your thoughts. This is the big ideas panel in the room, not to set the bar too highly. Leopoldo was in the last panel here. He's got to rise again to the next feature. We really have some of the key players in these negotiations and in the politics of all this, and I think this is an important panel. I'm excited to hear what all of these people have to say. I'm not going to interview them. I'm not going to introduce them each individually. You have their names. You should also have their biographies in your programs there. You can certainly find lots of reasons to be impressed with the gathering we've got here in their bios. We're going to keep this format fairly similar to what we've done in the past. We've asked each of the panelists to prepare 5 or 10 minutes. I think, 5-10 minutes, maybe a little bit less. It's going to be fairly short. I don't think any of these panelists has come with 60 slides for the presentation, as we had in the last one. But although I'd love to see the rest of the slides, but really. Ambassador Tony Gardner, if we want to start with you, and I will leave it up to you whether you want to take the podium and so on. Ambassador, the floor is yours.
I guess I'll speak from here because I'm half Italian and I like to use my hands. I gesticulate a lot. So when I was invited to this conference with a title that it has, TTIP, ISDS is the Achilles heel, I said, how could I not accept this invitation with such a title that's so controversial? I welcome any opportunity to discuss this topic because it is an important topic and we need more informed debate that's based on fact and based on the historical record and less on theology. I think that much we can agree on. Now let's start from basic principles. We're talking about this is a high-level session, so let's talk with high-level principles here. Taken together, the United States and the EU account for 2/3 of global foreign direct investment. And that foreign direct investment creates jobs and it creates growth. And a vast body of economic research shows conclusively that bilateral investment treaties containing ISDS are positively correlated with those foreign direct investment flows, again, that create jobs and growth. And particularly positively correlated in the sectors where there's a high degree of government involvement, mining, energy, and utilities. Together, the United States and the EU have a shared interest in the system of international rules that have been developed over 50 years to ensure that foreign investment is treated fairly and in a manner consistent with international law. And it's that system of rules that the EU member states have done so much to promote, more than anybody else. The Europeans created the first treaties, as we all know, on investment protection. They were the first to incorporate ISDS into those rules, and they've negotiated as many of those treaties as the rest of the world combined. Now, we believe that with regard to TTIP, it's important that ISDS is part of this agreement, because our ambition has been from the very beginning, as enunciated by the leaders when they announced the beginning of these negotiations, that we want to set forth 21st century rules on global trade and investment. And how could we say that we want to set the rules for global trade and at the same time say that the two leading global trading powers are not going to incorporate ISDS and try to incorporate the highest degree of protection for investment when, as I said, we want to do it for the rest of the world. Now, at the same time, we have not been deaf to the criticisms that have been made of ISDS. We have listened. In fact, we welcomed the EU consultation process. We went through a similar process ourselves, concluded in 2012 after several years with our U.S. model bilateral investment treaty. And our common goal, and the goal that was expressed in this bilateral investment, the model bit, was to find the proper balance between protecting legitimate protecting investors and stimulating investments on the one hand, and protecting the sovereign right to regulate in the public interest. And now just to remind you, our model BIT contains provisions that responds to a number of key criticisms in the following ways. First, it establishes a time limit within which plaintiffs can bring their case, so a statute of limitations. It deters frivolous lawsuits, vexatious lawsuits, and allows for their rapid dismissal. Third, it limits forum shopping and restricts parallel claims by investors through shell companies with no real economic interests. It allows signatory states to issue interpretive guidelines of their BITs that are binding on arbitral tribunals. It ensures the independence and impartiality of arbitrators. It allows third parties to file their own, to make their amicus curiae briefs. And it tightens the definitions of key provisions like fair and equitable treatment, including the meaning of legitimate expectations and expropriation. And importantly, under U.S. agreements, every document submitted by an investor in ISDS proceedings or by a state in response is required to be made available to the public, subject, of course, to the protection of confidential information. And our agreements also require that any hearings in ISDS cases be made open to the public. In short, there can be no secrets in cases brought under our agreements. Now, let me just address a few of the concerns that have been raised recently in the public debate. The first, ISDS favors investors. Well, it's just not true. Let's make sure we go back, all of us, and read the historical record. There have been some very good reports done by the UN Conference on Trade and Development and a number of other studies. And it shows quite to the contrary that states win more often than investors. The statistics are, of the 274 known ISDS cases brought to a conclusion, 43% have been decided in favor of the state, 31% in favor of the investor. With regard to the 117 known cases brought against an EU member state, 54 have been concluded. Of these, half of the cases were won by the respondent state. 1/4 of those cases were won by the investor. Now, in addition to that, what's very interesting is that the critics of ISDS rarely point out that when the investor wins, the average collection on those claims is 10 cents on the euro or 10 cents on the dollar. Perhaps that should be mentioned more often. The second concern, which I think has been misrepresented, is that somehow the number of ISDS cases has been skyrocketing. It's out of control. Well, let's look at the record again. Let's compare the number of cases. 56 is how it's been trending. Last year, I believe it's the number of cases filed. And compare to 1960, when the first BITs were signed. And let's compare the growth in ISDS cases to the total stock of foreign direct investment. It was $60 billion in 1960. In 2013, it was $25 trillion, 400 times as much. The growth in ISDS claims, in fact, is roughly proportional to the growth in the stock of foreign direct investment. Now, in light of the 3,000 investment agreements in existence, I would also not characterize 56, 55 cases per year as particularly large. And let's remember again that over 90% of the investment treaties are functioning with no treaty breaches being alleged by investors. The third concern, which I think has been misrepresented, is that, and this is key, that ISDS somehow undermines the sovereign right to regulate. There's a chilling effect somehow on the state's ability to pass legislation to defend health, safety for consumers and protection of the environment. What the critics typically don't mention is that the threshold, I think you've heard today already, for bringing a case is quite high, at least under the new generation bilateral investment treaties that contain ISDS. You have to prove a fundamentally abusive behavior by the state, a denial of justice, discrimination, expropriation, failure to follow fundamental principles of justice, including due process. Now, it's true that ISDS seeks to prevent the state from acting as it wishes in an arbitrary and capricious manner, but I would argue, and I would submit to you, that what's so bad about that? Preventing a state from engaging in this arbitrary and capricious behavior is actually something we should want. Now, critics are wrong to suggest that investors can easily bring a claim when their expectations of making a profit have been interfered with. In fact, there are very few cases, I would suggest, having gone through the record, which shows that investors can, in fact, collect money simply because their expectations of making a profit were interfered with. And those who cite cases are doing so very selectively. The vast bulk of ISDS case law shows that guarantees have to meet this high level of proof. Now, we've had treaties with ISDS in place for 30 years, and that has not led us to dilute our protections for health, environment, or labor, or consumer protection standards. And by the way, it's the same thing in the European Union. Bilateral investment treaties containing ISDS have been around for 50 years. Does it mean the EU has somehow diluted its degree of protection for consumers or the environment or health or safety? I think the answer is no. The fourth concern that I think has been overplayed and misrepresented is that we don't need, we've had a discussion I think among several of us here on the panel, we don't need ISDS between systems, advanced legal systems in the world. Well, there are 2,400 such agreements in the world, many of you know, and there are many of those 2,400 between developing countries. The EU is negotiating a deal, or has a deal now with Singapore, CETA is with Canada, TPP includes Australia, New Zealand, and Japan. All of those, of course, are developing countries with advanced legal systems. And we have concluded bilateral investment treaties containing ISDS, also with advanced countries with advanced legal systems. The inclusion of those rules is not motivated exclusively by concern about the quality of an investment regime. They are included because they represent an important element of the rules-based trading system, one that has overwhelmingly benefited the United States and the European Union. Of the 1,426 BITs to which EU is currently a party, nearly 200 are intra-EU BITs. EU member states clearly feel that their own investors need protection when investing within the EU, and investors in the EU agree. Of the 117 known ISDS cases to be initiated against an EU country, 88 were filed by an investor in an EU country. Now, investors come to see me almost every week, literally almost every week, and they tell me we need this, including within the EU. Why? And this is their argument, not my argument. The 28 member states have varied legal systems. They don't provide an even, a consistent degree of legal protection. And all you need to do is to look at the World Bank's Ease of Doing Business indicator or Transparency International's reports to see that that's absolutely correct. The 28 member states of the EU do not provide equivalent degrees of legal protection. Another concern that's raised, and maybe I'll close with this, the concern is raised that EU member states are more often targeted than doing the targeting, that they're being frequently sued under ISDS provisions. That's simply not true. The majority of those being, well, not targeted, but those who are the respondent countries are in Americas and in Asia. And can we really be surprised that Argentina and Venezuela are the most frequent respondents, when those two countries rank 147 and 148 out of 148 countries in the World Economic Forum's Index on the Efficiency of Legal Framework in Challenging Regulations? They ranked 106th and 160th, respectively, in Transparency International Corruption Perception Index. Now, by contrast, EU states have been respondents in only 20% of known cases, the Czech Republic and Poland being the most frequently cited. The claim that ISDS and TTIP would open up the floodgates of U.S. litigation is simply wrong. Now, critics often argue that U.S. investors frequently file arbitral claims against EU states and win. It's just not true. In the past decade, investors from the United States have filed 6 cases against an EU state. Of the cases that have been concluded, EU states have won more often than U.S. investors. On the other hand, EU investors have been the far more active users of ISDS in the world, far more so than U.S. investors. They've been responsible for over half of all known ISDS cases and twice as many cases as U.S. investors. And the trend is becoming even more pronounced, with EU investors accounting for nearly 2/3 of known ISDS cases during the last few years, with only 10% for the U.S. Now, we think that there are strong reasons why ISDS should be in the agreement. Now, let me just end with this thought. We are not alone. 14 states wrote a letter to the Trade Commissioner saying, we think this is an important part of this agreement. It's part of the mandate. It was part of what was announced when we launched these trade negotiations. We are not alone. 155,000 responses to the EU consultation document, 145,000 of which were based on template answers that were prepared by other organizations. So let us be careful in jumping to the conclusion that somehow European public opinion is against. Thank you.
Thank you, Ambassador, for... I think we can already see from the Twitter wall that you are provoking a debate, Ambassador Gardner. Thank you very much for your lively opening comments. Mr. Chairman, your responsibility now is to follow that and to be equally lively. The floor is yours.
Yes, ladies and gentlemen, thanks a lot for the invitation. And indeed, I will now speak not as a chair of the Intercommittee, but as a rapporteur for TTIP. That's a difference you can understand because the committee as a whole has not just make a clear position on that. But the European Parliament made clear towards the agreement on CETA to Canada in 2011 that the Parliament didn't want to have ISDS in the CETA agreement. So there is a clear indication for the attitude of the Parliament. But nevertheless, I will speak as a rapporteur for TTIP. And in my point of view, ISDS could be really the reason for getting TTIP in troubled waters. I think there are really good reasons to discuss on a good trade agreement with the United States. And I personally won't have the risk that this would be the reason for a failure of the agreement, especially because I am convinced that it's either economically necessary nor politically. There are several studies looking in the question, has ISDS a significant impact on investment? I think that's the reason behind. Otherwise, it makes no sense. And of course, we need investment in Europe, no doubt about, especially in the southern countries. But has ISDS an impact on investment? There's a study looking towards Brazil. There's a lot of investment, and they had a controversial discussion about ISDS, and they have no ISDS, and nevertheless, there's a lot of investment. Or look inside the European Union. The member state with the most US investment in Europe. You can take as an indicator the GDP or the inhabitants or other indicators. The country with the most US investment in Europe has no ISDS, it's Ireland. And of course, the other criteria were relevant for investment. Tax, of course, the market situation, infrastructure, and so on. So economically, I think it's not really important. And secondly, politically. Yes, I think the old ISDS regulation, and nevertheless, I think Germany is a little bit responsible for that. The first regulation, not with a clear ISDS, but in any case, investment protection outside the normal legal system was created by Germany in 1959 in an agreement with Pakistan. These old-fashioned ISDS systems are really not in line with the right to regulate for the countries. And we have several cases where it is really clear. Sometimes the decision of the arbitration courts are different, but that's the exception. One case is the Norwegian company had the right to regulate the parking space in Lithuania. And there the court decided a little bit different from the normal practice. But that's an exception. So if we are talking about ISDS, we should talk about an improved ISDS. Otherwise, you can forget it. And indeed, in the CETA text, my impression is there's an improvement. More public, the courts and publication of the documents and of the judgment, and the possibility to have a revision. That's also important. The judges are more or less controlled, and some clear requirements are foreseen in the CETA text. For example, that an investor has to have a substantial business activity in the country, so that not these post-case possibilities are still allowed. So there is an improvement, but nevertheless, there are also some leaks in the CETA text. For example, the question of the fair treatment is not really clear, even that there are some limitation compared to the old-fashioned ISDS, but I think we need a really restrictive definition about this fair treatment, and we have to make clear that fair treatment and public interest are two different issues. And for example, I think an umbrella clause dealing with all state regulation at all levels is also not acceptable. And therefore, we have to reflect further on the ISDS regulation and perhaps further improvement, and perhaps reflect if the best solution would be to go in the direction of a state-to-state dispute settlement system. And even in the CETA text, one area is covered by the state-to-state direction. It's the financial market. Why not take this model and introduce it to all areas of this agreement? And last not least, who should allow to use this instrument? Every investor, or only the investors which are clear, accept and implement the OECD guidelines for CSR? I think it's not only the right for an investor, it should be also an obligation for an investor who wants to use ISDS. Thanks a lot.
You hear me? Is that, oh, there I am. Thank you very much. That's interesting. Already we've got the debate shaping up here. I think we can entertain all the way to the cocktails and perhaps even through the networking cocktails if we want to keep that going. JanKrainer is a member of parliament, a social democratic member of parliament from Austria. He's zipped across here to tell us a little bit about how he sees the debate there. I should say, if you don't want to stand up for the future speakers, you're more than welcome not to. But if you want to take the podium,
being a parliamentarian, this is almost our natural way of talking. Thank you. No, I think almost all parliamentarians are used to talking like this. Thank you very much for the invitation. I think that establishing the rule of law is one of the major steps in civilization. Democracy, of course, being not less than that, but still the rule of law as itself being a very important step forward. And I think that the first ISDS clauses, Germany and Pakistan in the late 50s, tried to enlarge this rule of law to parts of the world where at least some of the world thought it wasn't established yet. Austria itself, we have, I think, 65 around bilateral investment treaties, all or almost all containing ISDS. We mostly with emerging and developing economies, but also with members of the European Union, all dating from a time before they were members of the European Union. Austria has never been sued. Austrian companies have sued other countries, but still we have a big debate on ISDS in our society, not only the Social Democratic Party, but in the entire Austria. Why that? A lot of triggers. One of the triggers was our neighboring country in north of us, Germany, being sued for their law of closing down nuclear power plants by a Swedish company, I think Vattenfall, and that triggered, and a lot of other things triggered the debate. In the meantime, we're discussing our bits and saying, and we're discussing, for instance, one thing about our bilateral bits, and that is that an Austrian company should not be able to sue another country because they changed their rules or regulations to a higher, at least from our perspective, to a higher level that is still below ours. Because we want to import or export good environmental laws and not prohibit the exportation of good environmental laws to other parts of the world. And the main topics we're talking about ISDS now, according to TTIP, is that we think that the European Union and the United States have established high standards on investor protection. I don't have the feeling that an investor in the United States is really being treated bad and needs a big quantity of protection. Austrian investors are in the United States. I don't think they're being treated bad there. A lot of American investors are in Austria. I don't think they're being treated bad in Austria. We don't have a bilateral investment treaty with the United States, but still we have a lot of commerce going on and a lot of investments. We don't really know why we should give an American investor a better chances or more rights than an investor from Austria or from Germany. Why should they have more possibilities? We in Parliament, this is what I'm saying here is I'm a Social Democrat. You might be used to hearing it from Social Democrats to have a critical view on ISDS. But in the Austrian Parliament, we had a 4-party vote, including the Social Democrats, the Conservative Party, the Liberal Party, and the Green Party, saying that we actually don't want ISDS included in TTIP. And the government is just, at the moment, negotiating a similar motion that would be passed tomorrow morning, saying that we actually don't, we're not one of the 14 countries that wrote the letter. We're one of those other 14 countries that didn't write the letter and are looking in a total different direction. We don't think that we need ISDS, if I understand it correctly, that if we establish TTIP and if we write into it that we don't discriminate the others, then it's a part of the law in the United States, with or without ISDS. And every court in the United States has to obey this non-discrimination. And I think that within the European law system we have, of course, there's different levels of law, and not all 28 law systems work exactly the same, but we have a supranational court system, the European Court, where every investor from Austria, from Germany, from wherever can go there and get their right at the end of the day. And I think it's just fair to say it's also open to every investor from the United States. And he will not be treated worse than anybody else of us. And I think that's fair. And I think we should go ahead and negotiate TTIP, but without ISDS. Thank you.
Getting the microphone. Okay. Can you hear me? Yep, there I am. I'm back. Leopoldo, I'm conscious of the fact that you worked long and hard in the last panel and so on, but I'm sure you've got another 5 minutes in you on investment policy. Not that it's your life or anything.
Thank you very much, and good afternoon again, Your Excellencies, ladies and gentlemen. I must say that You know, I shouldn't be saying that as a European official, I don't know. But anyway, I love my job because it brings me to this sort of events and to hear so many different points of view. We've talked a lot about ISDS this afternoon. ISDS is the most effective way to resolve disputes arising from the breach of standards of investment protection included in international agreements. It is a way to resolve disputes in an independent manner and in a way that brings politics away. I think in Brussels jargon we call it depoliticization. It is a system that is well known in Europe, and the more than 1,300 bilateral investment treaties linking member states with about 150 different countries in the world that include ISDS have not prevented the European Union and the member states to pursue and implement the highest standards of environmental, consumer or health protection, or labor and social legislation. And we're also one of the places on earth where human rights or cultural diversity are best protected. Conversely, investment protection and ISDS has allowed European companies to seek to resolve a certain number of disputes in third countries. ISDS is a means to enforce investment protection rules. So the debate about ISDS, when we say whether there should be ISDS or not in any given international agreement, is not really about that. It is about whether there should be investment protection rules or not. And so saying that there should not be investment protection rules is tantamount of saying that there are countries that consider that national treatment, compensation in case of expropriation, or fair and equitable treatment are things that should not be forming part of international rules. We hear the concerns that are voiced. We hear them very clearly, including at today's conference. These concerns are based on an existing system of agreements, of which half have been concluded by EU member states. This system needs reform. This system needs reform, and many of the concerns that are voiced are based on a certain number or a limited number of ISDS cases, a large number of which have not been concluded yet. There is very little mentioning of those cases which have allowed European investors to actually resolve disputes. But the system needs reform. And we have said that already long before we started the TTIP negotiations. We said that back in 2010 when the Commission, in a communication to the European Parliament, the Council and the other institutions, indicated that it wants to improve the ISDS system very significantly. We have already done a lot through two important negotiations that we've just concluded. We believe we have provided much more clarity on the investment obligations, which have all been geared towards limiting unwarranted interpretations and allowing us to continue to believe that with those agreements in place, the European Union and its member states will continue to be able to legiferate in pursuing those public policies that we want. We have also reformed deeply the investor-state dispute settlement system. Now the investor-state dispute settlement system is fully transparent. Unfounded cases can be dismissed at an early stage. We have no possibility to have parallel claims. In the case of failure to agree, arbitrators must be chosen from lists which have been drawn previously by the contracting parties. Ethical rules apply, and the losing party, and we've heard today clear statistics, that is in most cases the investor that brings a claim, the losing party bears all the cost. And we believe that this latter point, in combination with greater clarity on the rules, is very important in terms of avoiding any risk of regulatory chill. But we can go further. We've just heard the Honourable Lange telling a certain number of things about further improvements that could be brought. And we certainly do not want to stop the discussion. We can go further in, for example, trying to see whether these standards of protection can be looked at again. But we also have an important project, which is the setting up of an appellate mechanism to make sure that the reasoning of the tribunals is reviewed and that arbitral awards are more consistent. We want to continue negotiating on investment protection and on ISDS because we believe that we can bring improvements to the system and that these improvements are going to allow us to progressively replace the member states' bilateral investment treaties with EU-level treaties with the same third countries. And this is a very important point. What the European Union wants to do is that it wants to replace the systems and bring about a very significant consolidation of international investment agreements. As I said, we want to improve, and as I said, we want to listen. And this is why we've launched a very important public consultation, which is now coming to an end. We will soon publish a report presenting the responses we have received in the public consultation. And we don't want this to be the end of the story. On the basis of this report, using this report as a background so that there is, I would say, a lot more information about what this consultation has brought, we want to continue the debate. We want to debate with EU stakeholders, we want to debate with the European Parliament, we want to debate with our member states so that we can determine the position that the EU should follow in the TTIP negotiations. Thank you.
Thank you, Leopoldo. Robert Weissman is the president of Public Citizen, which is an organization which some of you may not be familiar with here in the EU, but has an incredibly influential voice and has long had an influential voice in the trade debate in the US. Robert very kindly flew in this morning, I'm told, to take the podium here.
Thanks. And my excuse for standing up is so that I don't fall asleep while I'm talking to you. Well, I wanted to thank the organizers and everybody participating. I think this has been really an extraordinary conversation. I think it's pretty clear how it turns out, but I think excellent interventions from all around. And I wanted to thank you, Sean, also for moderating all day. And I hope that my kindness to you will be reciprocated with some extra time to talk. So I think one of the things that's been really great about today is just the deep dive into what's a technical issue, and it can become very technical. And I think it's been really elucidating. I want to pull back from that in a moment. I just want to address one technical question up front, one particular argument that Leopoldo is making that I think is highly misleading. And then I want to pull back and talk about the issue in broader terms. And that's this issue of whether or not this distinction that he's trying to make between the enforcement system and the substantive piece of an ISDS regime, and the claim that an absence of an ISDS protection in a trade and investment agreement shows a lack of commitment to the principles he's raised of national treatment, minimum standards, and compensation for expropriation. And it's just not so. It's just not so. So the United States exercises all of those principles in its domestic law, as do countries around the world. But the United States does it in its domestic law as regards investors from anywhere in the world, irrespective of whether or not we have a bilateral investment treaty or other ISDS provision with them. That's just how it is. And that's true for the Europeans as well. So the alternative to ISDS is not mass expropriation. It's enforcement of domestic law equally to domestic parties and foreign investors. Now, a foreign company named British Petroleum recently polluted, actually engaged in the worst criminal act of pollution probably in American history. It's a foreign company, and it's been fined, or it's been criminally charged, but it's treated exactly the same as if it were Exxon, another large company that's engaged in mass pollution in our country. It had the right to appeal all the way to our Supreme Court, including an appeal against a settlement into which it voluntarily entered to satisfy private claims against it, decided it didn't like the settlement it entered into, and our courts gave it multiple bites at the apple to try to make that claim. Foreign companies get full protection under domestic law, exactly the same level of protection as do domestic companies. And that is the appropriate way, in my view, to handle these matters. Now, let's step back from this particular point and talk about the more general issues. I think one problem with the focus on the details is we get engaged in jargon and lose sight of core principles. We talk about ISDS, which is a ridiculous acronym to describe a corporatized, privatized system of injustice that creates highly specialized rights for foreign investors that exceed those of domestic investors or domestic citizens. There is going to come a time in the not distant future when humanity looks back on the system that's been created across the globe through ISDS and wonders how it ever could be so. And our choice right now is to decide whether we want to further that system, continue this travesty of creating extra corporate rights, or actually restore our democracy and restore basic norms of law. Now, in the context of the US-EU trade agreement, you can't imagine a worse place to include these special corporate rights. It's a terribly misguided solution to a non-existent problem. We know it's a non-existent problem because we've got trillions of dollars, trillions of euros of cross-border investment going on right now in the absence of any of these special corporate rights. There are 25,000 EU subsidiaries operating in the United States, 50,000 American subsidiaries operating in the European Union, almost all of them without special ISDS rights. Somehow they decided they'd take the crazy risk. They went ahead and they did it, even in the absence of a TTIP with ISDS. There are strong domestic courts on both sides of the Atlantic with no plausible claim whatsoever that there is a need for some special extraterritorial access to justice. Now, against that, the proponents of ISDS have to invent justifications that don't actually have to do with the parties involved. We have to have an international standard. We can't justify it for the parties who are actually negotiating. Let's just imagine that there should be some new international standard. Well, that might be okay if it weren't a harmful standard that we want to impose on the rest of the world, and if there weren't enormous risks, almost certain dangers that we are inviting by including these provisions in a potential TTIP. It is, at its core, a horrible idea for the reasons that have been elaborated in some detail here. Sort of just to pull out three of maybe the key things that are coming forward. One, we're creating super corporate rights, super rights for foreign investors exceeding those available to domestic investors and to domestic citizens. We know, as a matter of fact, based on experience, that that will lead to regulatory chill. It will both roll back particular regulations, it will block the enforcement of specific standards against corporate wrongdoers, and it will deter government officials as a matter of certainty from taking more regulatory steps forward. More on that in a couple moments. Second, right, I got a couple moments, right? Second problem is that we have a flawed structure of privatized justice, not using the normal court system, not using law and order as it's established in our democratic traditions, but relying on outside privatized arbitration panels. And third, we've got a fundamentally corrupt process with lack of transparency, limited rosters of deciders who aren't publicly accountable but are privately accountable. It's been interesting to hear the business representatives and the negotiators, at least from the European Union, acknowledge some version of all of these problems. So yes, we have all these problems, they say, but let's try to improve the system. Let's not try to improve this system. It's a fundamentally flawed system. Let's discard a system that has huge problems and no potential serious benefits and just say we don't need to take the risk. Moreover, if we try, it's not just a matter of a cost-benefit analysis on these systems, though that's a good enough reason. The nature of what has evolved is fundamentally not fixable. We have an overly complicated system to which the solutions proposed are more complications, more elaborated definitions of fair and equitable treatment, and on and on. You know what? The negotiators can't foresee everything that happens. They're not smarter than the corporate lawyers who are going to make use of these systems, even if they're operating in good faith, as I believe they are. And at the end of the day, bad things are going to happen. This is my last area, Sean. But I got like 6 subpoints. So let's talk quickly about the trend. So the trend does not really reasonably go back to 1960 to look at the uptick in increase in ISDS filings. It goes back over the last decade where it's increased not quite, but almost by an order of magnitude. This has zero to do, or close to zero to do, with the increase in rates of foreign and direct investment, and everything to do with clever lawyers who figured out a new area of business, a new culture of legality, and a new opportunity to push back against governmental regulation. And so that means what we've seen now is not what we're going to see going forward. It's a hint of what we're going to see going forward, because we're going to see more and more cases as they keep pushing the boundaries further and further. The Philip Morris case against Australia and against Uruguay, where the tobacco giant is pushing against public health regulations, is decisive in showing that itself should be reason enough to reject the system out of hand, by the way. That case itself should be reason itself to reject this out of hand, and it is having an enormously chilling effect throughout the developing world on exercise and implementing important public health safeguards related to tobacco. But it's a plausible case. It's a highly plausible case under ISDS. Now, as it happens, I wrote about this case long before it happened, about more than a dozen years ago. That's right. It's been filed, not decided, and already had impact. You talk to health regulators around the world about whether they're willing to do what Uruguay did, and the answer is no. No, it hasn't been, and that's exactly the point. In the absence of it being decided, public health regulators are already chilled from doing it. Your only reason Uruguay is still running the case at all is because Michael Bloomberg is funding them. Guess what? Michael Bloomberg can't fund defense of regulatory protections around the world. The Philip Morris case shows what chilling effect. It seemed like it couldn't have happened a dozen years ago, although people, including myself, predicted that it would. And the lesson of which is not that some of us saw what was going to happen in advance. It's that crazy things, crazy scenarios under ISDS actually are going to come true. They're already happening, and they're going to get worse. Look at the Eli Lilly case against Canada, attacking Canada for its patentability standards. We're going to see a greater and greater intersection of intellectual property claims and ISDS cases. The European Union and the United States are talking about a regulatory convergence chapter. Consider the intersection of ISDS and regulatory convergence. You're basically setting up a system where if a regulation does not comply with the regulatory convergence chapter, not only is it a violation of the regulatory convergence chapter, it's potentially a case waiting to be brought under an ISDS system. We're going to see more claims in the area of financial regulation. Even if the United States decides not to include financial regulation inside the TTIP, there's still a possibility of many important consumer protection and systemic financial protection rules being attacked through an ISDS backdoor effort to undermine important domestic and even international protections. This is a system that has already spun out of control, but we're only beginning to see the beginning. We have a choice right now about whether we want to let this go on, whether we want to give control of our democracies away to giant corporations, the only ones who are plausibly going to make use of this, or whether we want to regain and reclaim control of our regulatory processes. I think that's an easy choice to make. It's important that we do.
Thank you, Robert. And who says trade is boring? Nobody. It's amazing the level of consensus we're achieving on this stage. Thank you, Robert. I think that leaves us to our last speaker of the day before we come back to a discussion on the panel here. Monique Goyens from BEUC, which is an organization that I'm learning to pronounce every day. BEUC, thank you so much for putting on with Friends of the Earth Europe such an interesting day. The floor is yours for some closing comments before we turn back to what is going to be a lively discussion.
Thank you. I decided that I would remain seated because I'm the weak woman on the panel, so I use that privilege. But well, it's difficult to say something after Rob's speech. But first of all, before going to the notes that I had prepared as a closing notes, I would just like to make 3 comments. First of all, I would like to make a suggestion to Ambassador Gardner. Please Mr. Gardner, don't be dismissive with responses to the consultation in ISDS. I think it's really very... I think, of course, there has... ASBERG, Friends of the Earth Europe, and ACA Europa, we know how difficult it is to mobilize public opinion on such issues. And here there has been a mobilization. Of course people have been helped. Like farmers have been helped when there was a consultation on the review of the Common Agricultural Policy. Like sometimes industry associations help their members to respond to public consultations. This is just fair. But please take this as a political signal that is being given by the European public opinion. And don't joke about it, because some organizations have organized it. This is normal at civil society organizations. That's why we are there. That's our mission. It's to help bring citizens closer to the decision makers. So it's an important signal, and it should be looked at that. And I think the European Commission has understood that also as a very important signal. What I also wanted to say is second remark is about investment, and it's a little bit, what are we talking about? Like you say, it's a little bit technical, but at the end of the day, investment is about taking risks. And if you want to invest in a corrupt country, well, then take the risk. Huh? And we all agree in this room that investors should be protected, but they should not be pampered. So I think that there should really be a fair level of risk that has to be taken by investors, and there should not certainly be a discrimination in favor of foreign investors to the detriment of the national populations, the citizens, and the domestic companies. And then also, third remark is that there has been quite some acknowledgement by everybody that there are abuses, or that the current system is biased. That's good. I mean, that's already the first box ticked for as far as our campaign is concerned. But what we would really like to see now is that those transparency exercises that are being made currently by the European Commission would really be completed also by engagement with the stakeholders, in order for us to be able to see the text and to provide constructive input at a moment where it's still time to influence it. Because wording doesn't make a difference if there is no change in mindset. That's for sure. Because like the notion of legitimate expectation. I'm a lawyer. I can tell you that means everything. So this is really quite difficult. Now, to come back to my prepared notes, more or less. What I wanted to say is that what struck me today, all over the morning and the afternoon, was that we have received an enormous amount of well-reflected, fact-based, evidence-based information and arguments about ISDS from very different stakeholders. This was not a civil society club, hammering on ISDS. There were academics, there was, of course, business people, there were people from ambassador from South Africa, and so there were so many different stakeholders expressing concern about ISDS. And what I have certainly a lot that I still need to digest, a lot of new information, a lot of new reflections that have to take place. But what I heard today is that foreign direct investment doesn't have a close relationship with ISDS, so you don't need it. That also South Africa has told us that you can get rid of bad bits. You just have to take the decision politically to do so. CETA, even if it is an improvement, still has leaks or loopholes in the text, and it's still not the best system, the best model that we should stick to. Whatever we do in Europe, we have been told today that the US would stick to their model, and so what if it's different from the EU model? So we cannot anyway negotiate it, so why should we still work on a better one if the US are not going to change anything? And I also heard that alternative options exist. So when we then look at the so limited economic benefits of ISDS that have been also described over the day, and all those very important risks that are linked to all the flaws that exist through the system, well, why should we really keep it? Why should we keep it? Why don't we use this energy that you use for defending a system? Why shouldn't we not use it to invent or to improve those alternative options that exist? That would certainly be a win-win situation for everybody. And when I hear this argument about EU and US have to set the global standards, this is a precedent that we can use later, and well, then use your energy to set the global standard without ISDS, but set it with the alternative options. Why not? Why do we stick just because it exists? I mean, just get rid of it and start a fresh perspective on that. And that's what I really would like to say. I said it already this morning. The system seems to me too flawed to be fixed. after one day, I can confirm, and also Rob said it, how can this be fixed? So get rid of ISDS, use the energy to set a 21st century investor protection system, and try to get now a fresh and intelligent conversation on TTIP without ISDS. Thank you.
Monique, thank you very much. We have 5 minutes according to the official schedule, but can we go over a little bit? Are we happy there? Maybe go 10, 15 minutes, yeah? Are we okay with that, Ambassador? Yeah. I have a huge number of questions, and I could just monopolize things and do it here, but I'm much too democratic for that. So I'm going to go to the back of the room. Now, 2 people who have their hands raised are people who have already asked questions, and then we've got a panelist in the front row. I'm going to ask that first, can we go to people who haven't asked questions first yet, and the gentleman here, and then we will see what's left. So the gentleman here, and then in the middle there, and then in the back. Yeah.
Yes, my name is Geert Witsema. I'm from Friends of the Earth Netherlands. Sorry for that.
They've got a lock on
I can't help it that we're just a very active group in all kind of European countries. But I have a question for the European Commission, which is the following. What happens if one member state, such as Austria, keeps resisting the ISDS? Are you going to respect that, or are you going to use means to maybe compel that member state to sign? That's what I'm wondering. Is it possible that one member state could block ISDS? Because then we are basically done, if that's the case. Thank you.
That's a very good question. If I can add my own question to that, to the politicians here, which is, do you see ISDS as reason alone to block a bigger TTIP agreement? And I asked that conscious of Sigmar Gabriel and his intervention in the German parliament of a couple of weeks ago, where he said, I don't like ISDS, but CETA is bigger than ISDS, and we can't oppose CETA as a whole, as a government. There were a couple of other questions there in the middle of the room here, and then in the back.
Hi, Lynn Aikman for EU Trade Insights. Leopoldo, you mentioned the appeal mechanism as one of the ways to improve the ISDS and TTIP. I think this has been, you tried to negotiate this with Canada, and it's not in the final deal. So first of all, why is it not there, and how do you think you can put it in with the US? And Ambassador Gardner, is that something, an appeal mechanism, something the US would agree on? Thanks.
And in the back of the room there.
Craig Willey, German Press Agency. I had a question for Mr. Bernd Lange and possibly the Commission. Do I understand correctly that you would include rejection of ISDS in your report of the European Parliament? And what has been the reaction to other groups if you have made that suggestion? And second, for the Commission, if the Parliament rejects ISDS in a resolution or a report, would you take it out of the negotiations, given that it's a Commission prerogative, but would they respect the Parliament's will? Thank you.
Okay, thank you very much. We got 3 very interesting questions there. Leopoldo, we keep coming back to you on a lot of these questions. Do you want to kick it off?
If I find how to switch this. Thank you very much. The way the European Union conducts negotiations on trade and investment is the following. The Commission is authorized to negotiate by a Council decision. This Council decision in relation to the TTIP was taken unanimously by all the Member States. And all the Member States said, yes, Commission, negotiate investor state protection and investment protection and ISDS, but please be aware that when you come towards the end of the negotiations, we're going to check very carefully whether the results of these negotiations address the EU interests. And the inclusion of investment protection ISDS will depend as to whether these provisions that you have negotiated with the United States address the EU interests. Once the negotiations are over, the Commission has done its job. It is then to the European Parliament to decide whether or not to give consent to the agreement. And if the Parliament decides not to give consent, it's over. There is no agreement. And then it's up to the Council to decide whether an agreement can indeed enter into force. It is for the Council to decide whether an agreement can be concluded and then signed. Depending on the contents of the agreement, the way the decision that the Council is going to take, the way the voting system will be either unanimity or qualified majority voting.
This question of an appeals mechanism?
The question of an appeals mechanism, we didn't have time to negotiate it with Canada. We wanted to, but we also wanted to conclude the negotiations quickly. So this is why we said the investment committee will have authority to discuss the creation of an appellate mechanism. An appellate mechanism is something that is, Linek, you said it, is not the panacea. It is one of the possible solutions. It is something that requires a little bit of thinking. In relation to the United States, we know that the United States in previous official documents has indicated an interest in negotiating and forming and creating an appellate mechanism. And so on that basis, we consider that it could be something useful to do together before we indeed stop to negotiate pending the outcome of the consultation. It would seem to us that if the two biggest economic blocs representing 50% of world investment agree on an appellate mechanism, then de facto you have already an embryo of something that could be generalized at a wider level worldwide.
Ambassador, do you want to add to that?
No, I think that's exactly what I would have said. But can I address a separate issue, or should we go to Kayan to talk about it? I'd just like to ask our Austrian friend, has Austria signed the European Charter of Human Rights? Yes. Is it because Austria does not recognize fundamental principles of human rights? No. So why did it sign? Because it's an important principle to enshrine in international agreements. The same thing on ISDS. Saying that somehow signing ISDS is a recognition, or saying rather that we don't need ISDS because the internal legal systems of states provide equivalent protection, is not a perfect answer. It's not a good answer in my view. It's important for those principles to be enshrined in international agreements, which we hold out to be models for the rest of the world. I absolutely disagree entirely, however, with the premise that there's a chill on investors. Sorry, a chill on states. I would say there's a chill on investors, actually. There's absolutely no proof that there's been a chill on the sovereign right to regulate. We've seen every decade in the EU and the United States, as I said, standards fundamentally going up, not down. Why do I say there's a chill on investors? Before an investor brings a suit, and I actually know this from personal experience, I was a lawyer doing arbitration, you have to think several times over. Oh, that's a terrible thing, I know. One has to think several times over before bringing a case, because you'll probably lose, and if you win, you will get 10 cents on the dollar or the euro. There's no chill on states. There's possibly a chill on investors. And it works reciprocally. Yes, there's special procedural rights that are given to investors, but just like an EU investor in the United States would also benefit from those rights. And in fact, I think it's perfectly legitimate because foreign investors are, by definition, more exposed. They don't have the same degree of influence that domestic investors do. And finally, it's interesting when people who haven't worked in the private sector go make the argument that protections are equivalent across the EU. Protections are fine in the United States. We don't need it. I can tell you that investors disagree. In the United States and in Europe, they believe they need it from their own experience. We've heard the words travesty, the use of the word corrupt, and so on. But let's be very careful. Let's try to keep this dialogue balanced and based on facts, especially when we cite cases that have been filed and not decided, whether it's Vattenfall, Philip Morris, and other things. Let me just finally make one point. Some people have said, well, why don't we use political risk insurance, right? Why don't we use that? I actually was in the business of trying to get risk insurance. If you can get it, it's extremely difficult to get, and it's extremely expensive. It is not a panacea at all. And I would actually like to see anyone to try to get political risk insurance for arbitrary and capricious behavior by a state against an investor. But with that, I'll turn it over to you.
Let's go to the politicians now. Kai, do you want to?
Well, investors tell me in Austria that risk insurance is the best thing you can have because you're sure to get your money back quite quick. First thing. Second thing, I think the United States is against crimes of war. But still, can an American soldier be ever prosecuted in Den Haag? No. Why? Because the United States doesn't want their army to be able, or parts of their army to be able to be prosecuted in Den Haag. That's your decision you made. We signed the European Declaration of Human Rights and the International Declaration, and we're also subject to this court, to the Court of Human Rights. Does that make us better persons? No. But what I don't understand, if we're for investment protection, why we have to sign ISDS? We just have to treat them okay, and I think we do. And we have to put it in our law system and have a good functioning law system. And our law system has its flaws. And of course, nothing is perfect. Austria is not perfect either. But I think it works quite okay. I don't like every decision our courts make, but I like our system, our court system. And I have faith in this system. And I also have faith in the European court system, because we're talking here about not only national courts, we're talking about a supranational court system, and at least historically, the United States court system is also supranational court system over the national states, historically at least. In the meantime, it is of course a little different. If I myself would say ISDS is a reason to vote no, yes, it is. Does that mean that will happen in the future? I can't promise it or something like that, but I can tell that we Austrians are we do a few awkward things. Like we have the only one-to-one model of a nuclear power plant. But we just, we build it, and then we voted on it if we want to turn it on or not, and we said, no, we don't want to turn it on. So historically, there are things that some other people would say, hey, they're a little cranky. So
I think history does point that way.
Yeah, at least in a few things. But I think it's okay. I mean, we said no to nuclear, and we live by it. And we say we're against, I don't know, GMOs in food, and we fought against the Commission to have the right to say we don't want it on our fields and we don't want it on our plates. And in the end, we succeeded, just like we succeeded not to turn on the power plant. So let's see what we do this time.
Mr. Chairman, Germany, of course, has a much more illustrious position in history. Over to you. This question of is ISDS a really enough of a reason to vote against a bigger agreement? Where would you vote if the vote were held today and ISDS was in there?
That's a really abstract question, but because nobody knows at the end of the day what concrete regulation will be in the text. So even for CETA, my understanding is that the process is not finished yet. Of course, there's a legal scrapping going on now, and I mentioned that there's an improvement in CETA, and I'm convinced, for example, that the Vattenfall case is not possible with the CETA regulation, but also there are some leaks and loopholes, and we need further improvement. And at the end of the day, then we get the translation, and the Council will discuss it, and I think in 2016 it will come to the European Parliament, and then, of course, we have also some possibilities to react. We can say yes, we can say no, but also we can say we have no ground for decision now. We need some additional papers and additional negotiations. So there's a long period of negotiation and improvement. So at the end of the day, we have to decide. But I think at the moment, nobody can make a clear judgment. But of course, we will make now our resolution on TTIP as a midterm review, looking what has happened in the last 1.5 years, what are our priorities, and of course, we will make also a statement on ISDS after the result of the consultation done by the Commission. And I'm totally convinced that there will be some improvements to the existing model of ISDS. And I think you can't make anybody a clear argument that we discussing improvement of ISDS based on the CETA text, and in CETA we would accept an old-fashioned model. So if there will be an improvement in the ISDS consultation, it has to also to be accepted in the CETA text. And clear, the mandate makes it not as a must. There was a clear, let's say, relative position by the Council compared to the original proposal by the Commission. So there is space for maneuver. And indeed, at the end of the day, the European Parliament has to decide. And remember, in the last legislative term, we rejected 2 trade agreements, one with Morocco and one on IPR in the internet, the ACTA agreement. And my clear advice towards the Commission would be respect the will of the European Parliament not to risk a second ACTA.
Okay. Monique, you wanted to weigh in there?
Yeah, just one little point.
Let's get you a microphone.
Thank you. I just wanted, because I see on Twitter that Ambassador Gardner wants a fact-based debate, for sure. But just to make one thing, I'm not an expert on the cases on ISDS, but you say that you have no evidence at all that there is a chill. Just take Vattenfall 1 and ask the city of Hamburg, who had to withdraw, as a consequence of the settlement it had with Vattenfall, it had to withdraw an environmental-friendly rule in order to get the case settled. Well, that's certainly a regulatory chill.
Is this on? This one's on as well. Okay. Listen, I'm going to come back to the floor for just one final question, and that really is only because it's one of our hosts asking it. So Magda in the front here, and then we'll wrap up on the panel here because there's cocktails waiting outside.
Yes, thank you very much. I will be very brief. Magda Stoczkiewicz, Friends of the Earth Europe. Thank you very much for joining us today, especially Ambassador Gardner. And you mentioned that the investors are coming to you every week talking about why they need ISDS. Made me realize that we are many who think that ISDS is not needed. So maybe we need to start coming to you every week and discuss why it's not needed. But my question is actually, you said that for the consultations there was a lot of people who used the platforms already prepared for ISDS. And why would you think that they haven't read what was written there and that they disagree? Why would you think that their voices should be disregarded? And one quick to our friend from the Commission, because you said in one breath, more or less, that you will take the results of the consultations and see what are the next steps, and then immediately afterwards that the Commission wants to negotiate the ISDS and the investment chapter. I see a bit of contradiction there, so if you can clarify. And having this moment, thank you also very much for everyone who joined us here and to our funders, which I forgot to mention at the beginning today.
Okay, so thank you to all of you, and thank you to the funders. Ambassador Gardner.
Well, I didn't mean to be dismissive, but when you consider comments that are filed on any particular issue, a comment that amounts to "I don't like it," period, should not be given the same weight as a comment that is reflective and based on fact and is a little bit more than just a one-sentence remark. And I understand that most of the responses to the consultation were more or less a sentence or several sentences based on a template. All I was suggesting is that we should not jump to conclusions that consultation or those responses are somehow reflective of European opinion. And I'm glad we're having this debate. I think we should have more of these debates, but as I said, I think we could all agree, let's have a debate based on calm analysis of the fact. And I have actually done my homework, and I've read the Myths and Omissions paper done by Public Citizen. And a lot of interesting ideas are in there. A lot of hard work has been done. But at moments in this paper, and I'll give you just one example, all right? Description of the Ecuador case, right? Not a single reference is made, despite 2 pages on this case, to the fact that this went to district court in New York, and he found that there was embezzlement and bribery of judges, and it was thrown out. And that's where I would simply say, let's continue this debate, but let's keep it balanced and based on the facts and the historical record.
Yeah, no, just to explain a little bit my thinking. As I said, we need to have, and Commissioner Malmström has said it very clearly, we want to have a debate with the European Parliament, with the Member States, with the EU stakeholders on deciding what we want to do on investment protection and ISDS in TTIP. This is one thing. The other thing that I wanted to say is that what the European Union wants to do is that whenever it concludes an agreement with a third country on investment, this agreement automatically replaces the Member States' agreements with the same third country. And that therefore, what we want to do is not just bring improvements by adding new agreements to the already large web of bilateral agreements, but is actually to improve the system and to bring about an important consolidation in the system. So we want to have better agreements and fewer agreements which address fully this fundamental question of the balance to be found between the protection of investors, Monique said we shouldn't pamper them, and balance that with the right to regulate. Because of course, the last thing we want to do with European agreements is that we all of a sudden then find ourselves in a situation that we cannot continue pursuing the policies which we believe in, and that is exactly what we try to do.
The chairman here was shaking his head as you were saying one of those things. I just want to get you to react quickly, and then we'll bring it to a close. Yes,
indeed. Of course, we have a regulation for the old existing bilateral trade investment agreements from 2012. Yes, you are right. But in this regulation, there's not mentioned that we have to change the old one into new one. We have to check if they are still in the line or with the values of the European Union. We could also close them down. So that's also possibly the consequence of this regulation for 2012.
Okay, show of hands. Should Leopoldo be allowed to respond here quickly? I think Leopoldo. I think we can take it outside afterwards, and over cocktails and in a calm and reasoned fashion. We can continue this debate. Listen, thank you so much for what has been a fascinating day. I've learned a lot. I hope you've learned a lot. I'm not sure anyone's opinions have been changed in the room here today as a result of things. Clearly, people came in here armed with ammunition, intellectual ammunition, and with a certain viewpoint on the debate of things. But I really do think that this is a debate that needs to be had and had more often. If nothing else, you have shown today that trade can draw laughs. It can draw provocations. It can be entertaining to watch. It can certainly be lively. Thank you very much. Put your hands together to our very kind organizers, and let's go have a cocktail.